Hi, welcome back everyone. This is Professor Ramirez with Business Law. Today we're going to be discussing Chapter 14, which is the sales contracts, agreements for consideration and the statute of frauds. Hopefully I know you guys like the shorter videos. I received some comments from you, so I'll try to keep it brief and short and to the point. But just want to let you know, like always, the PowerPoint is up on Blackboard. If you would like to follow along with the video, that'd be great. And as well as if you were to read Chapter 14 prior to reading this, I think the material or the subject matter would stick a little bit better, and you'll be able to follow along a little bit better. But let's go along and let's start the slides for Chapter 14. I hope you guys enjoy. Like always, feel free to email me or call me if you have any questions. Thank you guys. Let's move on to the next slide. Jumping on here to slide number 2, the chapter learning objectives for this chapter 14. So after studying this chapter, or reading this chapter and going through the PowerPoint materials, you're going to be able to at least know 4 points, or you'll be able to discuss at least 4 points. One of them is identify the elements required under the UCC to create an agreement for the sale of goods. As we know, last video, the UCC governs the sale of goods, or at least governs the terms for contracts for the sale of goods. Second, we're also going to be able to compare and contrast the element of consideration under common law and under the UCC Article 2. Third, we're going to be able to explain what this is, and I love the name, but it's called the Battle of the Forms. We're going to be able to discuss and identify what is the Battle of the Forms and what is it for. And fourth, we're going to be able to articulate when sales contracts, or when UCC sales contracts must be in writing, and specifically what the writing must contain to be enforceable under the statute of frauds. So those are the 4 points that at least were the broad points that we're going to be able to discuss during this topic, or during our discussion here or video. However, there's going to be other things we're going to discuss, but these are the main points for this chapter 14 in this video. Well, let's go on to the next slide and discuss a little bit more about this. Now, discussing here slide number 3, we had mentioned before in contracts where we discussed the prior elements, the offer, acceptance, consideration, on all of those matters. Now going into this is the UCC. Now on slide number 3, we're going to discuss the formation of the agreement for the sale of the goods. Now the UCC makes it easy or lax to perhaps maybe to form an agreement. It doesn't have to be very formal to form the agreement. Now it allows the agreement or the contract to be enforced based on just past commercial conduct, not necessarily an agreement, but the conduct of the parties that they previously did, the correspondence or verbal exchanges between the parties, and the industry standards and the norms of that industry. So perhaps maybe one example would be one individual buyer calls up supplier and says, I need 2,000 widgets to be delivered to my store tomorrow by 1 p.m. The seller may not need to formally respond with a yes, or yes, I can deliver it, or these are the costs. Even just by showing up the next day with the 2,000 widgets by 1 p.m., that's already, the agreement has been made. The buyer cannot say, well, I made you an offer, however, you never responded and I didn't hear from you, therefore there was no agreement. No, it can be industry standards and norms can just be if you make me an offer and I just show up the next day with the terms of the offer, then that's already an acceptance. That may be one form of acceptance. If perhaps maybe the seller can prove those are the industry standards, or those are the norms within our industry. Also verbal exchanges. If it can be considered that if somebody called up the phone and I need 2,000 widgets delivered by tomorrow at 1 p.m., they hung up the phone and the seller says, sure, I'll be there. They hung up and the next day he shows up with 2,000 widgets. Perhaps maybe that may be even enough to show that there's a contract and the contract is enforceable by the seller to collect a payment on those 2,000 widgets. So it just goes to show that these things on the UCC, because most of the time we're dealing with businesses, business buyer and business seller, they sometimes the terms or the agreement are a little more lax to be able to enforce that agreement for the sale or the buyer or the purchase of goods. Well, let's go on the next slide and chat a little bit more. Now discussing slide number 4, we're going to discuss the firm offer by merchants. Now, when we discussed in the last video, now a merchant, just for simplicity, a merchant is perhaps, maybe we'll discuss it as a business. Someone that trades or purchases in these type of industries or with these goods a lot of times, and perhaps maybe they even sell them to the public. Now, if the seller, the individual, the business that is selling, the merchant, if they promise in a signed writing to keep an offer for the sale of goods open for a period of time, then under the Article 2 of the UCC, this action creates a firm offer which is irrevocable. So the firm offer, it perhaps maybe says, I will promise to sell you, or I offer to sell you 1,000 widgets for $1 each. This offer stays open for 1 month. That is a firm offer which is irrevocable. So the buyer can come back later in 20 days, 25 days, or 10 days, whatever within that period, and can utilize that offer or take advantage of that offer and purchase it, because it's a firm offer, and the offeror or the merchant who made the offer cannot take it back. 10 days later, he cannot say, oh, never mind, I don't want to make that offer anymore because perhaps my supplies went up and things, or it cost me too much, or I'm losing money now with that offer, so I want to take it back. No, that was a firm offer made by a merchant, and which is irrevocable. Now, the firm offer, of course, it's only going to last for the amount of time that was stated by the offeror, or by other words, by the merchant seller. If no time period is stated for it to remain open, it will stay open for a maximum of 3 months. Now, not to say perhaps maybe it may be less. It depends on the industry standards and the norms, but in no way is it going to go over 3 months if there's no mention on the time period or when that offer ends. Now, this offer is binding on the offeror, the seller, even if the offeree, if the buyer, has paid no consideration for it. So even if it's just out there and saying, I'm going to sell you 1,000 widgets for $1 each, this offer will last for 30 days. Even if the buyer pay nothing for that offer or pay nothing for that time frame to keep it open, it is firm, it is irrevocable, it belongs to the buyer if he or she wishes to accept that offer from the seller merchant. Let's go to the next time we keep on this. Now discussing slide number 5, which is going to be the offers with open terms. Now sometimes merchants are wishing to engage in wish to engage in a sales transaction or just a sales purchase, but the parties, both the buyer and the seller, perhaps maybe they overlook or they are unsure about a key element in the agreement or the contract. For example, the quantity, the delivery method, perhaps maybe the payment terms, or even they leave out the price of the goods that are being bought or sold. Now these missing provisions of those quantity or terms or things like that, they're going to be called open terms. Now they're going to be acceptable under the UCC if there is evidence that the parties entered into the contract and other terms were significantly articulated to provide a basis for some appropriate remedy in case there is a breach by one party or the other. And now the UCC's this approach toward these open terms, say, is an example of what we discussed in the last video of gap filling, of filling in the gaps when the majority of the contract is fulfilled, but perhaps maybe there's some terms that were not plugged in or not discussed between the buyer and seller. Then the UCC already has the gap filling to complete that contract. Now the contract is still an enforceable contract. It is still a complete contract. However, with some open terms that the UCC has, that is going to use its gap filling terms. Now the UCC uses these fills the gaps by the parties' contracts by providing a variety of answers based on what the terms are missing. So it's going to interpret the contract, and it's going to obviously fill the terms what is in most reasonable or what is norm for that industry or those parties making this agreement under the UCC. Let's go next line, discuss this a little bit more. Now discussing here slide number 6, quantity. Now as a general rule, quantity is going to be a required term in the contracts. It's for the sale of goods. It's necessary to create an enforceable sales contract. However, with that said, like every rule, there's going to be exceptions. There are two major exceptions for the quantity rule. That is, two exceptions for not having quantity in the contract. Now, one, the quantity may be an open term. Remember, open term is something that was left out of the contract. So quantity may be left out or may be an open term if the buyer agrees to purchase all the goods that the seller produces. Now, if they want to purchase everything that the seller produces, this is going to be an output contract. Everything that the seller can output, think about it, just that can push out or output, everything that they have in their warehouse or that they're capable of producing, if the buyer wants to purchase all of that, then that's going to be an exception. We don't need to label how many exactly, how much products or how much good you're actually purchasing if you're just purchasing an output contract. I will purchase all the amount of widgets that you can make in 1 month. Then we don't, the quantity is not going to be a fixed quantity. It's just going to be an output contract. They will pay, buyer will pay for $1 for all the amounts of widgets that the producer can make in that month. Then the quantity is not listed, but it's an output contract. You don't need to list the amount you don't need to have the quantity or amount listed in the contract. Now, the second exception also is going to be quantity may be an open term, again, may be not be listed when the buyer agrees to purchase all or up to an agreed amount that the buyer needs for a given period. Now, if for instance, if there's the buyer perhaps maybe has, think about it, 10 motorcycles that he needs to sell, and each motorcycle has 2 tires. Now, if they say, for my 10 motorcycles, I need to purchase tires. Now, obviously, that the quantity is not there, but if every motorcycle requires 2 tires and you have 10 of them, then they're going to need 20 tires. It's not listed, the quantity not listed there, but it's everything that the buyer needs to fulfill their requirements. So with that, we can simply, now that's a simple example, but that's just one example. Say, why would I need 100 tires when I only have 10 motorcycles? But however, the seller can say, well, obviously you have 10 motorcycles that have 2 tires each. So obviously you meant that you wanted to put 20 tires. So I will supply you with 20 tires. Although the quantity was not described there, it can be said that the seller was meeting the needs of the buyer that has the 10 motorcycles. So again, first example, the output contract, you don't need to put the quantity. If the quantity is essentially, if the buyer is essentially buying everything that the seller can produce, then you don't need to have a quantity, an amount there. And then second, if the buyer is buying everything that they need, then that can be obviously an exception. And the second one is called a requirements contract. It is just basically meeting all the requirements of the buyer. Hopefully you got that one. Let's keep discussing this a little bit more. Now jumping into slide number 7, we're going to discuss other open term for the UCC and gap billing. We're going to discuss delivery, payment, and price. So how to determine what do we fill in for that if those are open terms and not written in the contract. For delivery, if delivery is not stated or is absent in the contract, if the place of delivery obviously is not specified, the buyer takes delivery at the seller's place of business. That's where the goods will be delivered, at the seller's plant or warehouse or just store. Also, if there is if no time of delivery is specified, the UCC has a gap filler. It's going to put for a reasonable time under the circumstances. So reasonable time, perhaps maybe still would need to be deliberated or determined by a court of reasonable matter to discuss what is the reasonable time for delivery of those goods. Now also payment. If payment is not mentioned, payment is due at the time and place where the seller is to make delivery, and obviously it's going to be able to be made in any commercially reasonable form. Perhaps maybe in a business check, cash, credit, debit card, things like that. Now, one thing I'm not certain about is maybe in a reasonable commercial form, such as cryptocurrency, Bitcoin, or things like that. I would not be certain if that is a commercial reasonable form to pay in cryptocurrency or in Bitcoin. Now, third one is price. The UCC is going to require the court to determine a reasonable price at the time of delivery based on the industry standards and the customs, and of course the market value of those goods at the time of delivery. So those are just a couple of the ways that the courts determine how to fill in those gaps with terms. We discussed the delivery, the payment, and the price. Of course, these are just some examples in contracts. They can be large contracts that individuals or the attorneys or that the buyer and sellers forget to list a lot of items. But these gap fillers are going to be determined by the courts and the UCC. Let's go on to the next slide now. Now here, jumping on to slide number 8, acceptance. Now, the rules provided by the UCC, the Article 2, or the code, for accepting an offer in a sales contracts, they're not going to be as rigid as the common law rules. Now, we discussed as the common law rules how the acceptance has to be given in order to formalize an acceptance. Under the UCC, the rules are not as rigid to make an acceptance. If an offeror does not clearly provide for a method or how to accept the offer, the UCC allows the offeree or the buyer to accept the offer in any reasonable manner. And it necessarily does not have to match the way the offer was made. It just has to be any acceptable, reasonable manner to say, I'll accept your offer. Email would be one way to make that is a very reasonable manner to accept an offer. Now, under the UCC, acceptance may still be affected even if the acceptance does not match the offer exactly. Now, the offeror can maybe change the offer a little bit, but that doesn't mean that the offer changes. It just means that the original offer was accepted. Even though it wasn't exactly, the acceptance wasn't exactly what the offeror said, then the offer is still accepted, even though the acceptance tried to change it a little bit. Let's go to the next slide on that one. Now, getting on here to slide number 9, the battle of the forms. Now, businesses, they frequently use pre-printed forms that they've used over and over again to conduct business, to initiate or to respond to an offer to sell goods. And these forms usually have blanks in them for the negotiated terms unique to this specific transaction or to this specific buyer and seller. Now, normally the offer takes the form of a purchase order from the buyer that it's going to contain several pre-printed clauses, which typically they're going to favor the buyer, because the buyer is the one giving the purchase order to the seller, and blanks that the purchase manager is going to fill in with terms, for example, shipment date, product information, quantity, things of that. Once the seller receives the purchase order or the order requesting, I want to purchase 100 widgets from you to be delivered tomorrow, then when the seller gets that purchase order, the seller would then typically issue an acknowledgement form, or also called an invoice, which has the pre-printed provisions which typically favor the seller of the invoice, and blanks to accommodate that specific transaction. So the purchase order, which are going to have the terms needed for the buyer, what the buyer needs, the buyer is going to put it in a purchase order, which is usually the terms are going to favor the buyer. Once that purchase order is sent and received by the seller, then the seller will initiate or provide an acknowledgement form or an invoice of that purchase order, which the invoice usually favors the seller, and detailing, the price and things like that, what the seller is willing to sell those items for. And then that's usually how the transaction would get done. To one purchase order from the buyer to the seller, and then from the seller to the buyer an invoice, and then the buyer can accept or deny the invoice. But let's go on and discuss a little bit more about these forms or about these matters. Now, still here sticking with the battle of the forms in slide number 10, we're going to discuss where perhaps maybe the purchase order and the invoice do not meet eye to eye. Now, in some cases, one merchant is going to propose certain terms or certain items in the offering document, which we discuss as the purchase order, which is generally going to favor the buyer. But the other merchant's acceptance states the other merchant being the seller, their invoice states something different from the offer. So when the buyer sends the purchase order to the seller, it said certain terms, but when the seller returns back the invoice, there's conflicting terms there. In such cases, most states they're going to use what is called the knockout rule, under which the conflicting clauses, the terms that were conflicting or did not meet, they're going to knock each other out, and neither of the clauses or neither of the terms become part of the contract between the parties. Instead, the courts are going to look to the UCC. They're going to look to the gap filler provisions to supply the term or to fill in that term that perhaps maybe did not meet the same standard. So if there are certain things that they're conflicting, the courts are just going to say take that out, and we'll put a UCC gap filler to complete that contract. Let's keep it go a little bit more, and let's discuss a little bit more about these battle of the forms. Now getting on to slide number 11, we're moving on into the statute of frauds. Now, I believe we discussed a little bit here in previous videos, but I just wanted to remind everyone the statute of frauds is going to be a legal requirement that certain contracts, they need to be in writing in order to be enforceable. Now, if there's enforceable, meaning if there's perhaps maybe a party that wants to sue the other party, or perhaps a party that wants to make the contract be enforceable in a court of law, then there's certain types of contracts that need to be in writing in order to be enforceable. Under the UCC, any sales contracts for goods valued at $500 or more, they must be in writing to be enforceable in the UCC or in the courts. Again, the statute of frauds, a legal requirement that certain contracts be in writing in order to be enforceable. Under the UCC, any contract that for the sale of goods that is valued over $500, that by the statute of frauds must be in writing. Let's go on to next slide and discuss a little bit more about what are the requirements in those contracts to meet the statute of frauds. Now here on slide number 12, continuing with the UCC and the statute of frauds. Now, to satisfy the UCC in the statute of frauds requirement, the requirement that it must be in writing, the writing must contain the following items. One, must contain the quantity of the goods. Two, the signature of the party against whom the enforcement is sought against. So if you want to enforce a contract against somebody, then that person who you want to enforce it against, they had to have signed the contract in order to be enforceable against them. And then third, language that would allow a reasonable person to conclude that the parties intended to form a contract. Now, a reasonable person must show that, based on these writings and these signatures, the parties wanted to be bound by this contract or agreed to these terms in the contract. All other terms and conditionals may be provided by testimony concerning oral agreements or past practices or industry standards that may be proven in court. However, the three things that must be in writing for a sale of goods or goods over $500, you're going to need to list the quantity. You're going to have the signature against the party who you want to enforce it against. And it's going to have to show that a reasonable person looking at the document must conclude that the parties wants to be bound by this agreement or this contract. Let's go discuss one last slide about the statute of frauds here. All right, guys, almost there. We're at slide number 13, the final slide with at least subject matter on it, and the final slide is going to just kind of wrap up things for the UCC, the statute of frauds. Now, the UCC, the statute of fraud, is going to provide a relatively lenient rule for sales contracts between two merchants, between two businesses. Now, a merchant who receives a signed confirmed memorandum from the other merchant is generally going to be bound by that signed confirmed memorandum, just as if they had signed it, unless they promptly object to it or they reasonably object to it within a reasonable amount of time. Also, the UCC, it's going to recognize that electronic records, emails and things like that, and signatures in a sales transaction are valid. Now that's a very important rule. Perhaps maybe now in a world where we try to be, everything's electronic, we do everything by Zoom, we do everything by or a lot of people do DocuSign now. Things like that are going to be valid. We do not need a wet ink signature. Electronic signatures for electronic records are going to be perhaps maybe, like I said, DocuSign are going to be valid for these contracts. This means that the hard copies with the original signatures, they're not always going to be necessary for courts to see. Emails, saying I accept your offer, or DocuSign, things like that are valid and enforceable. Although the UCC, it does not require electronic transactions, it makes it clear that a sales contract, it can be enforceable simply because it's an electronic form. As the new age, everything approaches, everything's on the internet. Now the majority of things are all electronic. I'm starting to see most of the contract we sign, most of the agreements we do, we never have a actual document in front of us. It is all online with DocuSign or acceptance, or you even have to sign it with your finger on an iPhone or a smart tablet, things of that. So as we move forward, we're going to see more and more just electronic contract where there was no original hard copy wet ink signature on there. Well, let's go on to the next slide. Just a couple more things, but this will be the last slide where there's subject matter on there. Thank you guys, but let's just go on the next slide and discuss what we're going to discuss next week. Well, we're here in slide number 14. This is just the final slide. Just a reminder, I wanted to thank you guys for watching this video with me and bear with me. Again, the PowerPoint is uploaded on Blackboard for you guys to see and follow along. This is just the next week. Next week we're going to be discussing chapter 27, the business transactions. I believe business transaction is chapter 27, and then chapter 28 the following week. But again, for next week, we'll discuss chapter 27, the business organizations, and this PowerPoint is should be already uploaded on Blackboard for you guys. Well, thanks a lot. Thanks a lot for joining me again in the video, and I'll see you again next week.